The next item of business is a Stage 1 debate on motion 23883 in the name of John Swinney on the United Nations Convention on the Rights of the Child Incorporation Scotland Bill. Can I invite members who wish to contribute to this debate to press the request to speak buttons now, and I call on John Swinney to speak to and move the motion.
Thank you, Presiding Officer. At a time when our country is wrestling with the difficulties and challenges that we face as a result of COVID, the disruption to our lives, the burden and the sense of loss that is being carried by every single citizen in our country, this debate marks a moment of enormous historical significance. A moment, if I may say so, Presiding Officer, in the current context, of joy for our country. A moment of commitment to the future of every one of our precious children in Scotland. A moment where Parliament takes the first steps to legislate to provide for the assurance of the highest levels of rights for every one of our children in Scotland today. Scotland is set to be the first nation in the United Kingdom to fully and directly incorporate the United Nations Convention on the Rights of the Child into our domestic law. In this, Scotland will act as a leader in human rights internationally and across the nations of the United Kingdom. Of course.
Alex Cole-Hamilton.
I'm very grateful to the Cabinet Secretary for giving way, and I congratulate him on an excellent bill this afternoon. But does he agree with me that in order to be leaders in the world of children's rights, we do need to have an age of criminal responsibility which is above the internationally prescribed minimum? And can he confirm to Parliament when the Act passed by this Parliament to lift it from 8 to 12 will actually be commenced?
John Swinney.
I think, Presiding Officer, the issues in relation to the age of criminal responsibility are well rehearsed within Parliament, and of course these issues will continue to be debated as a consequence of the passage into law of the legislation that Parliament is going to consider this afternoon, because what this legislation represents is the incorporation into our domestic law of the significant elements and issues of the United Nations Convention within the competence of this Parliament to enable Scotland to truly live up to and build on the important journey we have started to ensure that we have the highest level of rights in place for our country. And I think that moment should be celebrated and marked by Parliament today. And of course, that is helped by the fact that the Equalities and Human Rights Committee have unanimously recommended to the Parliament that the general principles of the United Nations Convention on the Rights of the Child Incorporation Scotland Bill be agreed to. At this important stage in the bill's passage, I would like again to take time to congratulate those who have advocated for this bill for many years. It is with their insight and passion that Scotland is now ready to take this momentous step on its journey towards fully realising children's rights. I am grateful to the children's rights organisations and the many children and young people who have been champions of the need for incorporation of the UNCRC since its ratification in 1991. Today, I congratulate these champions for getting us to this important part on our rights journey. I'd also like to extend my sincere gratitude to colleagues in public authorities. Despite extremely challenging circumstances in the context of the COVID-19 pandemic, they have proactively engaged with us and shown their support for the principles of the bill. I will continue to give careful consideration to the support public authorities need to realise the full ambition for the bill, and my officials are working closely with a range of stakeholders to ensure that accessible guidance, training and other materials are put in place as part of the implementation plan to support public authorities, practitioners, children and families. The Scottish Government is committed to maintaining this collaborative approach through the passage of the bill, its commencement and its implementation. I also want to celebrate the work of the Equalities and Human Rights Committee and how they engaged with and listened to the views of children and young people during the Stage 1 evidence. Over 50 written responses were received from children and young people. Additionally, the committee organised 7 events to engage with children and young people who would not ordinarily provide their views to Parliament directly. The importance of the bill to the real-life experience of children and young people can be felt in this quote. One child was reported by the committee to have said, "I think that if the bill becomes a law, it will make so many vulnerable and poor children and families feel much more protected." The strongest commendation from children in our society. The committee's engagement shows the excitement that children and young people feel about realising their rights and the rights of others was clear. Their engagement with the parliamentary process also demonstrates how important it is that children and young people are fully recognised as people in their own right and have a voice to claim their own rights. I would like to express my gratitude to the committee for its commitment to supporting children as rights holders to be active participants in the decisions that affect them. The committee's work is inspiring, and I hope it acts as a great source of encouragement for other committees and decision makers to do the same for what can be achieved if we listen carefully to our children and young people. On the 18th of January, the Scottish Government's response to the recommendations in the committee's Stage 1 report was published. I welcome the report and its recommendations. As set out in the response, I intend to bring forward amendments that deliver on a large number of the committee's recommendations. In line with my strategic commitment to a maximalist approach to incorporation, within the limits on this Parliament's competence, it is intended that the bill should ensure that compatibility with the UNCRC requirements is required in every instance where public functions are being undertaken. The Scottish Government is confident that the bill as drafted would not enable a public authority to contract out of its obligations under the bill. However, I have listened carefully to the case for making clear that those undertaking functions pursuant to contracts or other arrangements with public authorities should also be subject to the requirement not to act incompatibly. I am pleased to confirm that the Scottish Government will bring forward an appropriate amendment to strengthen the protection provided by the bill in this regard. Children and young people deserve to have their rights prioritised and upheld by all those undertaking functions, including those who are paid to undertake functions on behalf of public authorities. Guidance to support public authorities and those undertaking functions of a public nature to fulfil their duties under the bill will be provided as part of the implementation programme, and this will be developed in partnership with those bodies affected. The bill as drafted already recognises the importance of non-binding sources of interpretation that courts may take into account when they are determining a case. The sources include the preamble to the Convention, the first optional protocol and the second optional protocol, and those articles which have not been included in the bill because they fall out with the powers of the Parliament. In line with the committee's recommendation, the Scottish Government will bring forward an amendment that expands this list to include sources which emanate from the United Nations Committee on the Rights of the Child. Whilst it is the contents of the UNCRC requirements themselves which are authoritative, this amendment will recognise the important role which the UN Committee on the Rights of the Child plays in supporting the effective implementation of the Convention across the world. Further, I would like to highlight that the Scottish Government will bring forward an amendment to strengthen the Children's Rights Scheme obligation on Scottish ministers, as recommended by the committee. Section 11 of the bill requires Scottish ministers to publish a children's rights scheme setting out what arrangements ministers have made or propose to make to fulfil the duty not to act incompatibly with children's rights. I am very happy to make clear that ministers will always be required to include and report on the topics listed in the bill. The scheme will also be strengthened by requiring updates on arrangements to promote child-friendly complaints mechanism and ensure effective access to justice for children and young people. These improvements will ensure that Scottish ministers fulfil their role as a leader in relation to children's rights. The committee has asked for the bill to be commenced 6 months after royal assent. I continue to give serious consideration to balancing the current extraordinary demands on public bodies with the ambition to deliver legal protection for children's rights as soon as possible. The impact of the COVID-19 pandemic has been felt acutely by children and young people, disrupting their lives in previously unimaginable ways. Respect for children's rights in tackling the adverse effects of COVID-19 is critical. The impact of the pandemic and the United Kingdom's withdrawal from the European Union will continue to place additional burdens on children and young people for years to come. The bill is essential to our recovery and to the fairer, more equal society which the Scottish Government wants for Scotland's future. As such, I am keen to avoid allowing an extended period of time to elapse before the commencement of the bill. I acknowledge that the bill provides an opportunity to protect the rights of children and young people who have been significantly impacted by the current crisis. I am also aware there is support from a range of stakeholders for early commencement. I want to be clear that it is my expectation that readiness for commencement of the bill should be a priority for all public authorities. I would expect those public bodies to already deliver their services to children and families in Scotland in a way that respects children's rights. And I will consider further the issue about a commencement date as we reflect on all of these important issues that I have put on the record. Presiding Officer, in drawing my remarks to a close, I believe that this bill is an important step in supporting children and young people in fully realising their potential. There is a broad consensus that the incorporation of the United Nations Convention on the Rights of the Child into domestic law will advance children's rights across Scotland. It is time for Scotland to enshrine children's rights in Scots law and help make Scotland the best place in the world to grow up for our children. In conclusion, I move that the Parliament agrees to support the general principles of the United Nations Convention on the Rights of the Child Incorporation Scotland Bill and pave the way to assure the rights of every single one of our precious children in Scotland. I move the motion.
Thank you very much. I now call on Ruth Maguire on behalf of the Equalities and Human Rights Committee.
Thank you, Presiding Officer. I'm pleased to speak in this debate on behalf of the Equalities and Human Rights Committee. It's 30 years since the UK ratified the UN Convention on the Rights of the Child, which under international law sets out the civil, political, economic, social and cultural rights that all children are entitled to. And I agree with the Deputy First Minister that progressing this legislation is a moment of joy in what are very difficult times for everyone. Incorporating the most widely ratified human rights treaty in the world into Scots law is a landmark moment for Scotland. A new bill which legally obliges public authorities, including Scottish ministers, to respect children and young people's rights, placing them under a duty to not act incompatibly with the UN Convention. The bill will allow children and their representatives to take public bodies to court for breaches of their rights. This bill has been the focus of committee's work over the latter part of last year. We welcome the Scottish Government's maximalist approach that seeks to go to the very boundary of legislative competence to ensure children and young people's rights are respected, protected and can be fulfilled to their fullest extent in Scotland. In keeping with this maximalist approach, the committee considered it vital that children have their rights protected, respected and fulfilled as a matter of urgency. That's why we urged the Scottish Government to amend commencement provision to ensure this legislation comes into effect 6 months after the bill receives royal assent. I appreciate the Deputy First Minister's assurance that serious consideration is being given to this important matter. To inform our scrutiny of the bill, the committee issued a call for evidence on the 7th of September 2020, which closed on the 16th of October 2020. We received 153 written submissions on the bill, largely from organisations in the public and third sector. Children and young people are at the heart of this bill. That's why the committee held a dedicated call for views for children and young people. Crucial to its success was the Associated Facilitators Pack, developed with the assistance of Together Scotland, the Children's Parliament and Children in Scotland. It's evidence of their effort and skill that the committee received more than 50 responses from children and young people as individuals, from primary schools, high schools, modern apprentices and other children's organisations. We thank everyone for sharing their knowledge and time. Creativity and innovation didn't stop there. Responses included reflective writing and drawings, as well as stop-motion videos. And I would invite members to have a look at the ideas there. As you know, children are not a homogenous group. With the assistance of many voluntary groups like Scottish Children and Young People's Centre for Justice and Aberlour Guardianship, we listened and spoke to children under 12 years, young people between the ages of 12 to 18, young carers, young refugees and asylum seekers, young minority ethnic people, children and young people with additional support needs, care experienced children and young people, LGBT young people, and young people with experience of the youth justice system. Through these varied activities, we came to a real understanding of what they hoped the bill would achieve for them. At the Children's Parliament session, young participants said adults sometimes do the wrong thing because they don't understand children's rights. An example given was, and I quote, "If a child doesn't know how to tie their shoelaces, then people teach them. If a child doesn't know how to behave, then people punish them. That makes no sense." Young refugees told us about the importance of Article 22 of the UNCRC, that they have the same rights as children born in that country. They told us this meant they could dream of a future, could receive an education and health services like people living in Scotland. If they didn't have these rights, they said they would feel isolated. Our child-friendly version of the Stage 1 report, published simultaneously with the requisite Stage 1 report, ensured children and young people have a report that speaks to them, about their interests, and shows how their views were listened to and taken account of in the committee's considerations, and what happens next to the bill. If any of the young people or children that helped us are watching, I would just like to place on record and say to them directly again, thank you very much for your valuable insights and all your help. Almost everyone who shared their views with us through submissions, oral evidence or participation, whether academics or children, had one thing in common: an overwhelming support for the bill. This piece of legislation has the potential to put children's rights at the very centre of public authority decision-making. However, we believe, as the evidence to the committee has shown, there are areas where the bill can be improved. For example, we called for the definition of public authorities to be widened to ensure organisations such as private schools, housing, residential care and childcare providers are not excluded from the legal obligations in the UNCRC. This is because experience with the Human Rights Act 1998 has shown that courts have defined the term narrowly, exempting private or voluntary bodies when carrying out public functions. The committee believes this must not be the case under this bill, and so we recommended that the Scottish Government consults main stakeholders to investigate how the definition of a so-called hybrid public authority could be tightened to avoid similar issues arising. And we welcome the Scottish Government's commitment to bring forward an amendment to strengthen protection in this area. Under the bill, as well as the Children's Commissioner having the ability to take cases, children and representatives acting on their behalf will be able to challenge public authorities in court for infringing their rights. The new legislation would allow the courts to strike down legislation that's incompatible with any UNCRC requirements. However, submissions to the committee raised concerns about the accessibility of the existing courts and tribunals service to children. Our report called on Scotland's top judge to reflect on this evidence and to provide an update on progress being made towards developing a child-friendly court system in preparation for the new legislation. We look forward to receiving this progress update to inform amendments that have informed the amending stages of the bill. We made further recommendations aimed at improving access to justice for children and young people. For example, in relation to ensuring judicial remedies for infringements of children's rights are effective in practice. Rosemary Agnew, the Scottish Public Services Ombudsman, considered it important that remedies should drive organisational change and, vitally, should consider what children might want as a remedy. We're pleased the Scottish Government has agreed to amend the bill to require courts and tribunals to ask for the child's views on what would constitute an effective remedy. The committee, however, asked Scottish ministers to reconsider its position in altering the definition of remedy so it is just, effective and appropriate. One of the key operational mechanisms of the bill is the requirement on Scottish ministers to make a children's rights scheme to set out how they will comply with the duties in the UN Convention. Many stakeholders argued that the scheme could be strengthened to include measures to support children with protected characteristics and vulnerable groups. Juliet Harris from Together Scotland referred us to our consultation events as they showed that particular children struggle to access their rights. such as children whose first language is not English, those who might face food poverty, or those who cannot go to school. Una Brown from the Scottish Commission for Learning Disability called on the scheme to refer to the UN Convention on the Rights of Persons with Disabilities, so young people with learning disabilities, alongside those with other protected characteristics, see themselves in the bill. Otherwise, it might not be seen as being helpful to them in realising their human rights. Further inclusions were called for: access to advocacy support, legal aid, human rights education, and a child-friendly complaints mechanism, each one fundamental to ensuring children's rights are made real in practice. We welcome the Scottish Government's intention to strengthen the scheme by requiring ministers to include arrangements in respect of child-friendly complaints mechanisms and ensuring effective access to justice for children and young people. It would be helpful if the Deputy First Minister could clarify whether these amendments would address concerns around protected characteristics and vulnerable groups. In conclusion, Presiding Officer, I'll finish with a quote from a young engagement participant from the Carers Trust Scotland, who said, "The UNCRC needs to be out there and be known. Unless it's known about, it's just there. We need a public conversation about UNCRC and young people in Scotland." This highlights the critical importance implementation plays in the bill's success. Let's not just have the bill there, or think that now the UNCRC is incorporated. That's all we need to do. We need to make sure the bill works to advance the culture change we all want to see for our children and young people now and for future generations. Presiding Officer, the Equalities and Human Rights Committee supports the general principles of the United Nations Convention on the Rights of the Child Incorporation Scotland Bill.
Thank you very much. I now call on Alexander Stewart to be followed by Mary Fee.
Thank you, Deputy Presiding Officer. I'm delighted to be opening on behalf of the Scottish Conservatives on this important Stage 1 debate this afternoon. And may I begin my remarks by extending my thanks to the committee clerks and all those who provided extensive evidence on this complex subject. We are nearing the end of a long journey during which time this matter has been debated at various stages during different parliamentary sessions at Holyrood. For the Scottish Conservatives, the journey has been a long one. Back in 2013, the then Education and Culture Committee was asked to provide evidence on the Children's and Young People's Scotland Bill. We agreed, just like other parties across the chamber in Scotland, that we had an obligation to deliver better legislation and enhance the protection of young people. This chamber well knows, however, that we did not agree to some of the final key recommendations in that bill. With regard to the initial discussions during Stage 1 evidence, when the incorporation of the UNCRC into Scots law was mooted, our concerns were largely due to some issues about how the provision would be implemented. For example, we raised concerns about the fact that on certain points of law, the relation to the possibility of incorporation to UNCR into Scots law, there were differences of opinion between the Scottish Government advice and the legal profession, and also the Scottish Government and then the Children's Commissioner. Members who were present at that time know that the Scottish Government cited its own concerns, quoting Professor Kenneth Norrie, who said, to incorporate the Convention into domestic legal system for Scotland would be bad policy, bad practice and bad law. Deputy Presiding Officer, we have moved a long way over the last 7 years. Whilst the Equalities and Human Rights Committee stage is unanimous in its recommendations as to why the bill's principles are the right ones, I want to address some of the key points regarding some of the practical issues that remain, which have been identified within the report. Therefore, Deputy Presiding Officer, what are the facts which require to be put in place to ensure that we have good law? And can I remind the Chamber that the definition of good law depends on the following: a clarity of purpose, that it can be understood in simple language, that it has a strong evidence base, that it is workable in the course of acceptance by the public at large. With the criteria in mind, I think that the last one is a given. namely that the public and the clear majority of key stakeholders want to see the bill passed because they recognise the enhancing and protection of young people is vitally important. However, there are some hurdles that require to be overcome before it does become good law, and that will require amendments at stage 2 and at stage 3. Organisations such as Families Outside, in their briefing note, spoke about the need to have amendments that would strengthen the bill in many areas. These areas included improving access for free legal advice, improving data collection and supporting monitoring and evaluation. Training would be required for ministers, civil servants and politicians to ensure a better understanding and promote best practice for children's rights. All of these, Deputy Presiding Officer, have some merit, and amendments may well be put forward at stage 2. There may well be the need for the Scottish Prison Service, as well as the Scottish Courts and Tribunal Service, to be included in section 16 of the bill on public bodies, given their role and the helping to secure the rights of children. As a member of the Equalities and Human Rights Committee myself, I am most grateful to the support received in gathering evidence from individuals and groups who would benefit from this legislation, and there was extensive work done on that to ensure that we did capture many of the organisations and individuals and groups, Deputy Presiding Officer. Evidence from the children and young people groups themselves spoke about human rights experts, spoke about the public authorities, as well as the members from the legal profession who showed considerable support for changes in legislation and wanting to strengthen the rights for children. As a committee, we believe that, on balance, the bill's approach is appropriate. But there are some who have some issues that they want to bring forward, potential risks of incorporation being seen as having achieved the minimum in UNCRCH standards. And at part 3 of the bill, when we talk about the Children's Rights Scheme, several of the respondents that called for evidence, and also those who gave oral evidence, talked to the committee about the safeguards and the language under section 11.3 of the bill. They needed to be strengthened. And I've listened to the Cabinet Secretary today in his opening statement, who's talked about that needing to be strengthened, and that's to be welcomed. The bill states that the scheme may introduce certain arrangements around children's rights, and that many stakeholders calling for that is required. The scheme also spoke about with regards to protected characteristics and vulnerable groups, identifying the lack of access to advocacy, human rights education and children-friendly complaints mechanisms, which would and should be considered, as there are gaps in the provision for supporting children with these. And, Deputy Presiding Officer, with respect to commencement section 40, there was some strong support for the bill. However, many witnesses and respondents for the call for evidence and their views talked about the need for commencement because there was no commencement date in the bill. And we've also heard today the Cabinet Secretary is looking seriously at the commencement when that would take place. Also, during the current pandemic, it has to be recognised and acknowledged that children and young people have been significantly impacted in this crisis. Children need to have their rights respected and fulfilled as a matter of urgency, and therefore it is vital to ensure that a generation of children and young people do not suffer long-term impacts from the current crisis that they are facing. There has to be content about raising the awareness for the bill. It's also, we must ensure that barriers are removed to ensure that good work has already been undertaken, and much of that has been achieved. So in conclusion, Deputy Presiding Officer, we in the Scottish Conservatives fully support ensuring that much protection and enhancing the rights of children and young people takes place. However, there is no doubt that the bill raises many questions, and we all must acknowledge that much progress will be required to achieve this at stage 2 and at stage 3 amendments that may well come forward, not least how this will work alongside the United Kingdom Human Rights Act itself. We must recognise the various technical challenges which incorporating the UNCRC into domestic law may bring, and the potential for conflict caused by clashes between rights set in the reserve law and that within the UNCHR itself. The bill must not result in endless clashes of legislation and long-term lasting legal battles, because that's not what we want to achieve. But what we do want to achieve is support. So, Deputy Presiding Officer, we support the general principles of the bill and we will come forward with amendments at stage 2 and at stage 3. Thank you.
Thank you very much. I now call Mary Fee to be followed by Ross Greer.
Thank you, Deputy Presiding Officer. It is a privilege to speak in the Stage 1 debate on the United Nations Convention on the Rights of the Child and Corporation Scotland Bill and to open for Scottish Labour today. The significance of this piece of legislation cannot and should not be underestimated. It will have a life-changing and lifelong positive impact for all of our children. And as a member of the Equalities and Human Rights Committee, can I thank my fellow committee members for the consensual and productive way that we have all approached this piece of legislation. I'd also like to take this opportunity to thank our clerks for their hard work and dedication. And with a slightly more rushed timetable than we normally expect, I am grateful for their tireless effort to get us to this stage. I'd also like to thank the various organisations and individuals who presented written and oral evidence to the committee. We cannot do our jobs without this valuable input, and their time and expertise is very much appreciated. This is a pivotal piece of legislation and one which I am in full support of in principle. Any bill that we pass in this Parliament that makes our access to human rights more robust is one that we should all, no matter which party we are a member of, wholeheartedly support. And one of the biggest takeaways from the evidence sessions for me was that we are so fortunate to have so many organisations looking out for the best interests of our children here in Scotland. This is what this bill seeks to achieve. Through strengthening access to children's rights, we are acting in their best interest. Children in Scotland under the age of 16 cannot vote. And so, unlike the majority of the population, they have no choice in who represents them in this Parliament. That is why it is our responsibility to be the best voice possible for our children. We must always seek to protect them, to improve their life chances, and to ensure that they grow up in a safe and a secure environment that will enable them to become citizens who live lives of fulfilment. Every choice that we make in this Parliament that directly impacts a child's life must be taken all the more seriously. And the incorporation of the United Nations Convention on the Rights of the Child into Scots law would give our children more power over their own lives. It would give them more of their own voice. There is an old saying that children should be seen and not heard. Well, Presiding Officer, I disagree with this. When children are heard, we get to understand a different point of view. Sometimes we learn from children and not the other way around. If a child is in pain and we ignore that pain, it isn't just going to go away. It will become chronic. When we respect and empower our children, we can support them better and end any potential cycle of pain for them. And can I thank the Deputy First Minister for attending the committee and for his comments on our Stage 1 report. I do have a couple of issues I would like to raise, however. I do think we need an amendment to ensure that the definition of a public authority is robust. Having an updated definition will make the bill stronger and ensure that there are no issues of clarity further down the line. And this should be a priority at the second stage. And I do welcome the comments already made by the Deputy First Minister in this regard. And I appreciate that the Scottish Government intends for the bill to be commenced as quickly as possible. But we all have different interpretations of what this can mean. I therefore want to express my support for having a specific commencement timetable published. This bill is desperately needed, and so it is crucial that we are all on the same page. A timetable would allow us to do our job and hold the government to account. I'd also like to make it clear that it will be very important that we ensure that children are made aware of what this bill means for them. Children will not use the tools available to them if they do not know how to. We know that some children will have a more difficult time accessing the information than others. And this was a key issue that was highlighted in the evidence sessions. There needs to be ample resources to reach children in marginalised communities. Children who are part of the Gypsy Traveller community, children who are refugees, and children who are affected by imprisonment are just a few of the groups that need these resources. These are all groups of children who may face more discrimination than others, and it is vital that they understand how they can use their rights in practice. And in closing, Presiding Officer, we know that this has been an incredibly tough year for children, with their education interrupted, to spending little time with family and friends, and the uncertainty of what the future holds for them. By passing this bill, we can give them some of that certainty back. We can give them empowerment over their own lives, and we can ensure that they can always access their children's rights in a court of law. When we protect, but we also respect our children, we are giving them room to flourish. And finally, Presiding Officer, I look forward to listening to the contributions from across the Chamber this afternoon, and I give my commitment and the commitment of the Scottish Labour Party to work with the Deputy First Minister, colleagues across the Chamber and organisations who on a daily basis work to support and protect Scotland's children as this bill makes its way through Parliament. And I look forward to decision time when this Parliament will agree to the Stage 1 United Nations Convention on the Rights of the Child Incorporation Bill. Thank you.
Thank you very much, Ms Fee. And I call on Ross Greer to open for the Green Party. Mr Greer, please.
Thank you, Presiding Officer. This is the first stage in a historic process for this Parliament and for Scotland's young people, and a really important milestone in the wider efforts to codify international human rights treaties into our domestic law. I'd be remiss as a former MSYP if I didn't start by congratulating the Scottish Youth Parliament for having brought us to this point. Without their work and that of the Children's Commissioner and many others, this day would probably still be some way off. The Convention on the Rights of the Child is a landmark document. It recognises that children in particular need stronger rights protections that are tailored to their needs, and critically, which are accessible to them. What value are rights if you can't exercise them? The CRC incorporates both civil and social rights together in one document, recognising that these rights are interlinked and that children's well-being can't be assured without both sets of rights. After all, how useful are civil freedoms if you're starving or being denied healthcare? Too often, when poverty and inequality is widespread, civil rights are only really exercisable by those already privileged in society, those whose economic needs are already met. Historically, many treaties have separated civil and social rights into different documents. The International Covenant on Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights are an obvious example. Another would be the European Convention on Human Rights and the European Social Charter. The separation of these rights has also tended to undermine the legal protection of social rights in particular. There continues to be debate over the justiciability of social rights, as they lack the same history of court enforcement that characterises the development of civil and political rights. The move towards neoliberalism and austerity economics, particularly in the last decade, has seen social rights in the UK attacked and undermined. But across the world, there are many constitutional orders that do include social rights and afford them some level of protection. Unfortunately, this isn't the case here, a reason why our integration of the Convention on the Rights of the Child into Scots law is so significant. Here, we've seen the economic and social rights of children violated as successive UK governments have, for example, cut services and social security provisions and introduced an expanded conditionality into the welfare system. When these cuts have been criticised by UN rights experts, the UK's Conservative government has disgracefully attacked those experts. By placing civil and social rights side by side, the UNCRC seeks to ensure a holistic approach that upholds the well-being of children. And by transposing the Convention directly into our domestic law, this bill will open the possibility of legal enforceability of the social rights contained within the Convention. It's really hard to overstate how significant a development that could prove to be. The social rights of children and young people are critical, but without legal enforcement, we've seen how easily they can be cast aside. In addition to the prospect of legal enforcement, the bill introduces other ways to protect and uphold rights. It introduces a children's rights scheme designed to ensure children can participate in decision-making that affects them, and places a duty on public authorities to act in a manner that's compatible with the Convention. These are again welcome steps forward, and I can think of a number of examples from my involvement in the establishment of Eastern Bartonshire's Youth Council, in which such a duty placed on the local authority would have likely led to a different outcome. There are certainly areas where the government can go further here. The Scottish Youth Parliament have called for the Children's Rights Scheme to be made stronger, particularly around support for vulnerable children. They've also called for the definition of public authorities to be expanded to include private companies delivering public services. The Greens are happy to support these calls, and I welcome the Cabinet Secretary's commitment to strengthen the latter provision from his opening speech. One area of enforcement that's seen significant debate is whether this Parliament can essentially bind its future self by striking down new legislation that's incompatible with the rights of children. This issue has been considered by the Equality and Human Rights Committee, and I really appreciate their work and the very valuable inclusion of that in the report. And several academics have provided some particularly useful supplementary evidence. Constitutional protections that override primary legislation are a central feature of most constitutional orders, but it's one that's alien to a UK that's instead, and I think to our detriment, based wholly around the principle of parliamentary sovereignty, and whose constitution is muddled, to say the least. The Scottish Government have currently opted for a system of declaration of incompatibility for future legislation, believing that powers to strike down future legislation go beyond the competence of Parliament. This view has been challenged by academic experts, though, and I'd like to see a more substantial response from the Government. I'd encourage them in particular to take up Dr Boyle's recommendation to seek views from a breadth of experts in constitutional law. There's a danger that this close to dissolution, the rush to ensure the bill is passed on time, results in significant issues going underexplored. This shouldn't be the case with something of this constitutional significance. Whilst all this is of immense importance, it's also unavoidably a bit dry and abstract. It happens with constitutional law sometimes. In closing, I don't want to lose sight of the fact that this bill will have a transformative effect on the lives of children and young people in Scotland for a long time to come. It will be a part of the legacy that every one of us leaves in this place. And it will particularly benefit our most vulnerable young people. I was really struck by the comments made by the committee convener, Ruth Maguire, that came from young refugees in Scotland in particular. It's for these reasons that the Greens are, of course, happy to support this bill at stage 1 today. Thank you, Presiding Officer.
Thank you very much, Mr Greer. And I call Alec Cole-Hamilton to open on behalf of the Liberal Democrats. Mr Cole-Hamilton.
Thank you very much indeed, Presiding Officer. Can I start by thanking the committee clerks and indeed the witnesses, and particularly the children and young people who gave us very fulsome evidence in our consideration. I'd like to take this moment also to pay tribute to two old colleagues of mine, Juliette Harris, who is the director of Together, the Scottish Alliance for Children's Rights, and to Bruce Adamson, long-standing friends. He's the Children's Commissioner, who have fought tooth and nail to get us to this point, and I think it's to their credit that we're here. I also want to do something uncharacteristic, and that is to heartily congratulate the government on an excellent piece of legislation. It really is an excellent piece of legislation. It has surpassed my expectations and the expectations of many in the sector, and that is to their credit. In many ways, Presiding Officer, this day represents a penultimate step for me towards the realisation of a goal that I've been striving for all of my adult life as a youth worker, as an officer in a children's charity, and as chair of the Scottish Alliance for Children's Rights. Indeed, over 7 years ago, I once gave evidence to the Education Committee on behalf of the children's voluntary sector. I was the opening witness for the Stage 1 consideration of the Children and Young People Bill in 2013, and I may well have been the first person to actually articulate the desire to incorporate the United Nations Conventions on the Rights of the Child. I said this, I said, we want what you want. and that's in reference to the government. We want for Scotland to be the best place in the world to grow up. For us, the most elegant roadmap to that and the most elegant solution against the international standard is to incorporate the United Nations Convention on the Rights of the Child into Scots law. Until we do something like that, or we build the provisions into the way in which we make policy, we will forever be behind those countries that have already incorporated the UNCRC. Presiding officer, we are a step closer to that end today, and I am heartily proud of it. In this bill, we recast the way that we organise the conduct of human affairs in this country in a way that puts children and their interests at the heart of everything we do, and I congratulate the government for this. This legislation, however, will only serve the children it is designed to serve. It is a living, if it is a living, breathing document, one which we come back to and refer to and remind ourselves of time and time again. And it is well to remind ourselves in this chamber that the UNCRC, the convention itself, is only the foundation on which rights are built. It is the de minimis position, as the international community has determined. And it is part of a much wider ecosystem that is updated every single year. And so I heartily agree with our committee's recommendation that courts and tribunals must pay heed to things like optional protocols and general comments, concluding observations. And so too must the government in its application of the convention. I intervened on the Cabinet Secretary, who was kind enough to take me. I think he rather suspected what was coming, but it was General Comment 10 that said that it was the international belief of the UN Committee that no country could be observant of human rights if it had an age of criminal responsibility that was not higher than 14, and we remain at 12. We've not even achieved 12, but I hope very much we can improve on that. The committee also believed that public authorities must exhibit due regard in addition to acting compatibly with the UNCRC as it makes policy. This means that public bodies and authorities must bake children's rights into policy from inception, not just think about it in the latter stages and just check against the child rights impact assessment. It should be at the heart, in the fabric of everything we decide to do. This bill will also only be as good as the justice afforded to the children who seek it. And at the moment, navigating our justice system, if you're very young, is an incredibly intimidating prospect. That is why this committee has called on the Lord President, Lord Carloway, to look at reform of the criminal justice system to make child-friendly courts, or at least access to justice, more child-friendly. And it also asks that the government consider the implications for legal aid so that no child is prohibited from reaching out for that justice on grounds of cost. I think improving remedy doesn't just stop at the access to courts. It involves hearing the views of children about what would make their journey better, what would right the wrong that they have experienced. So hearing their voice is at the very heart of every remedy that we offer them. On reporting, absolutely. Again, ministers must make this a live document. So it's good that they have committed in the pages of this bill to come back to this Parliament and report on evidence of rights transgression in our communities and in our public bodies. But they should also say what action they intend to take on deficiencies that they have identified going forward. Finally, on child rights and welfare impact assessments, it's important that ministers not have an option on that. This should be something we do on every policy. It's very easy to think that certain aspects of our legislation aren't relevant to children, but children are stakeholders in our community. We are custodians of their futures for them, and as such, we should think about that in every piece of legislation that we do. Finally, this is, we've covered this several times already, but this is something I intend to put forward stage 2 amendments at, which is on commencement. A bill is only as strong, is only window dressing unless it actually becomes an act and is delivered on the ground. And I'm concerned, as with the Age of Criminal Responsibility Act, that we passed 2 years ago, that act is still not commenced. Rights will only be made real once they are real on the ground. And so I asked the Cabinet Secretary to meet with me to consider my amendment to see this commenced from 6 months past royal assent. This is a great day for Scotland, presiding officer, and I will close with the words of Nelson Mandela, who said that there can be no keener reflection of a society's soul than the way in which it treats our children. Thank you.
Thank you. I was somewhat amused by your finally. It's, quite a few people use that. Open debate. I call Gillian Martin, be followed by Jamie Green. Ms Martin, please.
Thank you, Presiding Officer. I want to talk in my contribution particularly about the outreach that the committee did on this bill. I think it's important to stress how valuable and comprehensive it was, and to commend the children and young people who took part. Their insights and their sharing of first-hand experience and their sheer enthusiasm for this legislation was really quite something. It's clear that the UN Convention on the Rights of the Child means an awful lot to the young people in Scotland. Over a month, we had 8 planned sessions with children and young people, as well as our public committee meetings with stakeholders. And we had sessions with children and young people of all ages, young people with disabilities, care experienced children and young people, asylum-seeking children and young people who've been the victims of trafficking. We heard from young people with experience of the justice system and from children of different ethnicities, as well as our new young Scots coming to us from countries across the world. And I was struck in particular by the strength of feeling towards the UNCRC and children's rights who looked after children and care experienced young adults. Young people who've often felt their rights weren't being communicated to them or addressed in the past, particularly on the right to see their families and to be involved in shaping decisions around their future. We heard many times that the UNCRC rights should be built into and be apparent in the everyday practices, the institutions and services they interact with, and the people they come into contact with. The guidance delivered as part of this legislation will be just as important as the wording of the bill. We heard some very compelling evidence in private session with a wide range of children and young people on how their views should be at the centre of decisions made about them. Actually, to be blunt about it, in short, decisions should not be made about them, but with them, and our recommendations strongly reflect this. Much of our stakeholder evidence and submissions and in our public sessions centred around this too, and many called on the Children's Rights Scheme to include a specific requirement in Scottish ministers to report on topics relating to access to justice, including avenues of redress when things go wrong, support for children with protected characteristics and vulnerabilities, and child-friendly complaints procedures and the right to advocacy services and legal aid. Josh Kennedy of the Scottish Youth Parliament said that child rights and wellbeing impact assessments should be published in a child-friendly format, and that children's participation in decision-making should be mandatory. I agree with them. Another thing that young people were particularly clear on was that children should know their rights, and that the UNCRC, as the UNCRC is incorporated into law, there should be more work done in ensuring that education on those rights is done throughout childhood. This was particularly clear in sessions we had with children who had experienced the justice system and the care system. In any given situation, their clear understanding of their rights should be ensured. A young person with experience in the justice system told us this: a lot of professionals automatically assume as young people with lived experience, we know about our rights when we don't. It's one thing to have rights enshrined in law, but it's quite another to have those rights proactively and appropriately communicated by professionals to children in a range of settings. This leads on to issues more generally about education around children's rights, and it's true a lot of this won't necessarily fit or be appropriate in the face of the bill, but I was pleased to hear the Deputy First Minister was mindful of the importance of rights education, not just for children, but for the professionals who come into contact with children and young people. I'm pleased to say that our Stage 1 report also has a child-friendly version, which practices what we preach. We feel that child-friendly communication from all public bodies interacting with children or making decisions that affect children to have documentation and materials that are easy read and understood by children. And we also recommended that these be in a range of languages. The convener and I spent a great Saturday morning with Lickety Spit Theatre Company, who work with young children across communities in Glasgow. Spending time with them, some of that time I had a toy caterpillar on my head, and taking part in their games and songs about children's rights, it was clear to me that even the youngest children can get a handle on their rights if the communication is appropriate. It also helps if it's fun, which that morning definitely was. I want to close by thanking the committee clerks and the outreach team. The work they put in to gather children's views was absolutely outstanding. And it's on the outreach and evidence gathering that the report recommendations and ultimately the success of this bill will stand. It's already a great bill, and I'm proud that Scotland's playing its part in fully realising children's rights. The testament of children in our scrutiny and the Deputy First Minister's clear and compassionate acknowledgement of what they've said is set to make it even better. Thank you, Presiding Officer.
Thank you very much, Ms Martin. I call Jamie Green to be followed by Fulton McGregor. Mr Green, please.
Thank you, Deputy Presiding Officer. Can I start by opening by saying, for the avoidance of doubt, that we do support this bill in principle, and if we voice technical concerns, I think that's a reasonable approach. It doesn't mean that we don't share the ambitions of the members of the committee or the Stage 1 report. And I'd like to thank members of the Equalities and Human Rights Committee, its convener, its clerks, and those who coordinate the committee's work in a very difficult time for putting together Stage 1. I know it's not easy. I was briefly a member of that committee, and I do know that its members, including Alex Cole-Hamilton and Mary Fee, who've spoken already, are so passionate about this, and I know a tremendous amount of stakeholder engagement also took place in difficult circumstances. Now, when this bill was introduced to Parliament and the Cabinet Secretary made a statement, I pledged that Conservative members would support measures that enhance the rights of children both in our domestic law and within international conventions. That does remain the case. But this bill has been a long journey because despite the convention being agreed to in 1989, it has not really been widely implemented, or I think often understood. So Scotland will be among one of the first countries in the world to do so. But UNICEF have pointed out why this bill is so important, and these conventions are relevant in today's modern world because they quote, "Millions of children continue to suffer violations of their rights when they are denied adequate healthcare, nutrition, education, and protection from violence. Childhoods continue to be cut short." And I think we've made progress both domestically and internationally in the last 30 years. But surely what's happened these last 12 months have only added to those pressures. Coronavirus has served to magnify many of these challenges, not just in Scotland, but throughout the world. Again, quoting from UNICEF, they say, "Children are not the face of the pandemic, but they risk becoming its biggest victims, because for some children the impact will be lifelong." And here in Scotland, we know that COVID is exacerbating challenges facing children. Those in our most disadvantaged communities, those in households with less income, they've invariably suffered through school closures, household job losses, and those at risk through the exposure of substance abuses in their house, domestic violence, and that lack of physical daily interaction and intervention from teachers who are trying their best, but who cannot protect every child in every household all of the time. Now, I know that our inboxes will also have been filled up over these past few months with a range of views on lockdown measures and restrictions and closures. And the very issue of what state intervention is and what are normally our rights and freedoms has actually raised that issue of what are our rights, especially the rights of young people, their right to an education, their right to social interaction, to exercise and to sport. Now, I would argue we don't always need legislation or philosophical debates on rights to improve the quality of life of people or make good existing deficiencies in their rights. That solution often already lies at the door of governments. The attainment gap, housing quality, the quality of their school estate, training and employment opportunities, the funding of outdoor learning and sport, meaningful LGBTI inclusive education, their experiences in care, their interactions with the justice system. These are already levers which government has at its control to improve outcomes for young people in Scotland. But nonetheless, the UNCRC is one such powerful method of putting that into law. As the Queen's University in Belfast stated, it has had a significant effect in places where it has been implemented. The Convention itself contains a number of obligatory and optional protocols which those who ratify it must consider. They are wide-ranging and it is no mean task for a government to introduce those. But we do stand ready on these benches to work with other parties, with the government, to ensure that we do enhance children's rights in Scots law. But I would say this, we also must make good law. There has been commentary as to how or if this bill does conflict with other human rights legislation, as my colleague said in his opening remarks, there remain outstanding questions about how this legislation will interact with human rights legislation. Could it conflict or interact with the 1998 Human Rights Act or the provisions set out in the European Convention of Human Rights? And if so, where there is interaction or conflict, which takes precedence and who decides that precedence? What assessments have actually been made about which areas of this bill covers between devolved and reserved matters? How will that interplay develop, and how will those issues be dealt with on as least a political basis as it can be? And if there are changes in the future to the respective United Nations conventions after this bill is passed, what effect will that have on Scots law? How will we keep pace? And is keeping pace necessarily always better if we do not know what those changes will be? There must be measures and mechanisms in place to ensure that those conflicts are dealt with quickly and easily. In the interest of time, I do want to make a further point, and that is that it would be remiss of us to talk about the rights of young people without reflecting on the views of the Scottish Youth Parliament, who I know have been engaging with members right across. They support this legislation. They want to see, they've made a number of asks, and I promised that I would mention them in the Chamber today. I know that the committee, in good faith, at stage 2, will consider the voices of young people further. But it's not all doom and gloom. We will talk about our technical issues with the bill, but I do take the Cabinet Secretary at his word that he will approach this constructively, as will we. I am, Presiding Officer, nervous, however, and it is my one reservation that we are trying to culminate 7 long years of hard work into 7 short, frantic weeks, ahead of an election and in the middle of a pandemic. That work will progress at pace, but it must also progress precisely, because I'm told by those who have been in this place much longer than I have, that this Parliament has a habit of rushing through bad law in its closing days. Given the genuine cross-party ambition to improve outcomes, I'm in my closing seconds.
Mr Green's just concluded.
Given the genuine cross-party ambition to improve outcomes for all young Scots, please let this not be one of those laws. Thank you.
Thank you very much. And I now call Fulton McGregor to be followed by Elaine Smith. Mr McGregor, please.
Thank you, Presiding Officer. And it gives me great pleasure to speak in today's historic debate. And oftentimes in this place we use the word historic, but few times would it be as appropriate as it is today, as hopefully come decision time we'll be one crucial step closer to passing this groundbreaking legislation that has the potential to improve the lives and life chances of Scotland's children and young people. Presiding Officer, up until the festive recess I was a member of the Equalities Committee and had the privilege of taking this bill through stage 1 and the evidence gathering. And although we look to the whips here, although initially disappointed to leave the committee, I think it's fair to say that having been involved in the progress of this legislation thus far has been a great honour and privilege, and I will stay involved through the remaining stages. And I want to thank the whole committee and the committee clerks for the scrutiny of this bill. We had some really good evidence sessions from stakeholder groups and a huge number of outreach events engaging with young people directly to inform our stage 1 report. And I think that was very well outlined by the convener, who herself, I must say, she probably can't mention this herself, but I think went to every single outreach event. And if anyone needed any more convincing of the historic nature of this bill, just take a look at the letter and briefing from Together, supported by over 50 organisations that work day in and day out with children and young people and have fought for a long time for this incorporation of the UNCRC into Scots law. Because by incorporating this into Scots law, we will build children's rights into the fabric of decision-making in Scotland. This bill will revolutionise the way we listen to children and take their rights into account. It will mean children and young people are involved in the decisions that affect their lives, and that children's rights are always respected, protected and fulfilled by public authorities who will be under a statutory duty. The bill ultimately shifts the balance of power and allows our children to use the courts to enforce their rights where these are not upheld. And I welcome the Scottish Government's response to the Stage 1 debate, and it's fair to say there wasn't a lot of areas of disagreement. I think actually Jamie Green made that point. There were the areas where there was more scrutiny around are more technical points, or perhaps in the committee's view strengthening of the bill. And one such area where I do welcome the Scottish Government's response is in relation to the Children's Rights Scheme, which we heard a lot of support for during our evidence gathering. For instance, the committee asked the Scottish Government to strengthen section 11.3 by amending the wording from may to must in the bill, and I'm pleased that this has been agreed. And I'm also pleased that the Scottish Government is to bring forward an amendment to strengthen the scheme by requiring ministers to include arrangements in respect of child-friendly complaint mechanisms and ensuring effective access to justice for children and young people. And these changes, amongst others, particularly in this area, in this section of the bill, are important to ensure that those who deal with children do so in a child-friendly manner, and that children who may not normally engage with the process, the so-called, for want of a better word, hard-to-reach children, are given the opportunities that others have. And we heard a lot about this in some of the outreach sessions that we attended, and how important it is that all children and young people from a variety of different backgrounds and communities feel included. And I would pay tribute to Mary Fee's speech on this point as well, when she talked about the Gypsy traveller community as one example. And there are areas where I feel there is scope for further amendments at stage 2, mostly of a technical nature, as I said, but one such area where there may perhaps be a bit more debate, I would suggest, is around commencement, as we've already heard. Together, and the 50 or so children's organisations are calling for commencement within 6 months of royal assent, and cite COVID-19 and Brexit as factors in this. At this stage, I would tend to agree with this, and I know the Scottish Government and the Cabinet Secretary have said that they are considering it. I know that the current pandemic places undue pressure on our statutory bodies like never before, but I think this is heavily and significantly outweighed by the impact the pandemic has had on our children's rights, with school necessarily disrupted on public health grounds, the restrictions in place around when children can see relatives and friends, their futures in doubt and their own health needs impacted like never before. It has never been more vital that their rights are upheld and protected with every measure possible. The pandemic has also laid bare the inequalities that exist, a point that was well made by Social Work Scotland in their submission. On top of that, children in Scotland are being faced with Brexit. Again, not of their own doing, and in this case something that the adults who care for them and had the right to vote didn't even vote for. So, in my own opinion, it's shameful that their rights have been walked all over in this regard, and with the double whammy of COVID and Brexit, Scottish children's rights should get the additional protection as quickly as possible. Presiding Officer, overall this is a very significant and historic bill, and may well be one of the most important laws that is passed by this Parliament, assuming that it gets to stage 3 and is passed. Organisations and political parties are largely united in Scotland becoming the first country in the UK to incorporate the UNCRC into law. And I want to finish by paying tribute to my constituent Ryan McShane, who many of you will know, and I know the Deputy First Minister does know. As a care-experienced young person and advocate of children's rights, I know this will be a very important day for him, and he can be very proud. I would like it placed on record here in our Parliament that I am grateful for his input to committee and directly to me as his MSP in this bill. Ryan, your input, your experience and insights, and that of all the young people who got involved and were engaged with the process, has been invaluable and much appreciated. So thank you. Thanks, Presiding Officer. I would urge the Parliament to vote for the principles of the bill at stage 1 later tonight.
Thank you, Mr McGregor. And I call Elaine Smith to be followed by Rona Mackay. Ms Smith, please.
Many thanks, Presiding Officer. And can I start by welcoming the Equalities and Human Rights Committee's support for the incorporation of UNCRC into Scots law, which I think is long overdue, and of course their work on the Stage 1 report. I also congratulate and thank the children, young people and all campaigners who've worked tirelessly to arrive at a point where children's rights will be enforced instead of being an option. Presiding Officer, you may recall that my very first members debate on my own motion on the 3rd of February 2000 was about the UNCRC and the work being done by statutory and voluntary bodies at a national and local level to uphold the UN Convention, and I focused at that time on the child's right to play. And I also called at that time for full implementation and for the statutory role of Children's Commissioner to be put into place in Scotland, and I'm glad we now have that position. In my speech at that time, I highlighted a local project in Kirkshaw's Coat Bridge, where parents, mainly women, worked against the odds to transform a local derelict site into a multi-purpose play area suitable for all, from toddlers through to teenagers. And their motivation was the apparent connection at the time with the lack of facilities for play and leisure in Kirkshaw's, and young people becoming involved at an early age with alcohol, drugs and vandalism. And I'm happy to say that the project, Parent Action for safe play was positive for many children and young people over the years. And I think that a project like this shows what respecting the rights of children looks like in practice, when the abstract legal position might seem a bit more difficult to grasp. The right to play and to have safe places to do that is one of many children's rights which have been seriously affected by the current pandemic. The access to something as fundamental as fresh air and a small piece of open space has been denied to many children, particularly those living in poverty. And during the pandemic, vulnerable children have been included with the children of key workers who can still attend school. But to fulfil our obligation to these children, we need to identify that they are actually attending. And I know that the NSPCC Scotland at the moment are concerned that given the low attendance by vulnerable children in the last lockdown, there'll be a similar pattern this time. Scottish Government's own report in April recognised that the number of vulnerable children will increase because of the additional pressures placed on families and communities by the COVID-19 pandemic. And so I hope that the Government is doing its best to standardise how schools encourage vulnerable children to attend and to contact children and families where they are not attending. Vulnerable children must be visible in the data to ensure that families who are struggling can access the help they need. Presiding Officer, eradicating poverty is also key to children's rights, and the soaring levels of poverty, coupled with the ending of the £20 increase in universal credit, will drive more families into poverty. The ethos running through the UN Convention is that of provision, protection and participation, and the three key principles that should be applied through Scottish law and policy are those of non-discrimination, the child's best interests as a primary consideration in all actions concerning children, and the child's view being given due weight. And as I said in that first debate over 20 years ago, mindsets need to be changed and mainstreaming of the interests of children must become second nature. The pandemic has shone a light on all inequalities, and the incorporation of the UNCRC into law will ensure that authorities will have to take this into account when developing policy, not only in response to an emergency, but at all times. Fundamental to respecting the rights of children is understanding that some groups of children find it harder than others to have their voices heard, and some members have already mentioned this. In particular, children looked after in a variety of situations by local authorities, those with disabilities, those living in poverty, or those whose parents have no recourse to public funds. Another area where we can show our commitments to children's rights is, of course, around provision of meals to children out of school, nutritional standards of those meals, and whether it's better to give parents cash payments. We really are talking here about the most fundamental right for children not to suffer hunger. And that is why, Presiding Officer, my proposed Right to Food Bill is very much part of the debate around how we treat children. My previous member's bill, which became the Breastfeeding etc. Scotland Act in 2005, was also very much focused on children's rights, and in that case was protecting the child's right to be breastfed in public. The Scottish Human Rights Commission has stated that incorporating international human rights treaties into domestic law is a critical component of securing their realisation. I know the committee have responded to the request of many stakeholders, including Together Scotland, to amend the commencement provision at stage 2 to ensure the bill commences 6 months after royal assent, and I note the Cabinet Secretary's comments on that. But I hope that sufficient help will be given to public authorities to prepare for this, and that the Government does agree to look into this as outlined at the start by John Swinney. The financial memorandum to the bill focuses on costs to rights awareness raising, but I'm not convinced it fully addresses the existing situation in which our local councils find themselves. We know they're struggling to deliver ever-increasing services passed on from the Scottish Government without sufficient funding. From nurseries and schools to decent housing, reliable and preferably free broadband and suitable devices for study and space and opportunity to play, we need to commit to what this incorporation will look like in practice. So in closing, Presiding Officer, can I say we need the political will together with the essential funding to do that, so that Scotland can truly become a world leader in protecting children and young people's rights. Many thanks.
Thank you, Ms Smith. Now I call Rona Mackay to be followed by Alison Harris. Ms Mackay, please.
Thank you, Presiding Officer. The bill we're debating today is crucial to the future of our nation, and I'll be delighted to pass the general principles at decision time. In fact, to quote the Cabinet Secretary, it will be a joy. It's crucial because it underlines the Scottish Government and this Parliament's commitment to giving children a voice and respecting their rights. These children are Scotland's future. I couldn't be prouder that Scotland is set to become the first country in the UK to directly incorporate the UN Convention on the Rights of the Child into domestic law, and I congratulate the committee for all their hard work on this. By implementing this to the maximum extent possible under the current powers of the Parliament, we will build children's rights into the fabric of decision-making in Scotland entirely as it should be. Crucially, the bill also allows for incorporation of the articles of the UNCRC currently beyond the powers of the Scottish Parliament, should these powers change in the future. The bill will deliver a proactive culture of everyday accountability for children's rights across public services in Scotland. Presiding Officer, since being elected in 2016, there are 4 pieces of legislation which stand out for me above all the other important bills we've passed since then. These are the Vulnerable Witnesses Scotland Bill, the Domestic Abuse Scotland Bill, the Children's Scotland Bill, and of course John Finney's Equal Protection Bill. In my view, these lay the foundation for a systemic shift in emphasis on children's rights from a society where children have traditionally not been consulted on a whole host of issues to one where they will be listened to and respected. This bill is a significant step towards a future based on tolerance, equality, shared values and respect for the worth and human dignity of all people, whatever their age. It is indeed one of the most significant pieces of legislation since devolution to help all children reach their potential. It will include rights relating to health and education, disabled children's rights, leisure and play, fair and equal treatment, protection from exploitation and the right to be heard. These rights apply to every child and young person, whatever their ethnicity, sex, religion, language, abilities or any other status, whatever they think or say and whatever their family background. It will mean children and young people are involved in the decisions that affect their lives and that children's rights are always respected, protected and fulfilled by public authorities. Public authorities, including the Scottish ministers, will be under a statutory duty not to act incompatibly with the UNCRC requirements as set out in the bill. If they do, children, young people and their representatives can use the courts to enforce their rights. This will deliver a proactive culture of everyday accountability for children. Presiding Officer, in a private evidence session for the Children's Scotland Bill, we heard from Yellow, a young expert group for improving justice in child contact cases, supported by Women's Aid and advocacy workers. All had experienced a fraught journey through the justice system. Their evidence was intensely moving and compelling, and their bravery and honesty was awesome. They spoke of their experiences of being victims of domestic abuse, pawns in horrible adult mind games, their feelings of not being listened to, of not feeling safe, of no one asking what they wanted when they were in court, of being invisible, of being made to have contact with someone they didn't feel safe with. In short, adults making decisions for them without consulting them. Presiding Officer, they were the adults in the room on the day we heard their evidence, and they made the Children's Bill their bill, as it should be. And I'm delighted to hear about the child-friendly bill initiated by the committee. Their experienced young people too contributed so much to that bill with their powerful evidence. And that's why I'm so pleased that the UNCRC Scotland Bill will put power into the hands of children and young people and reaffirms our commitment to make Scotland the best place in the world to grow up. Through the responses to the Scottish Government's consultation, it's clear there's widespread support for directly and fully incorporating all of the rights set out in the Convention. Many organisations expressed their wish for this, but for the legislation to be put in place without delay, and I wish that too, and I'm pleased the Government will consider this at stage 2. I'm also pleased that the committee recommendation to replace the wording in section 11 from may to must has been agreed by Government. Bruce Adamson, the Children and Young People's Commissioner for Scotland, said, "The bill is really strong. It builds on an understood framework that we already know through the Human Rights Act 1998, and importantly, it strengthens it. The bill contains specific measures to remove barriers that children and young people may face in realising their rights under the bill and accessing justice. These provisions include giving the Children and Young People Commissioner in Scotland the power to raise claims in the public interest. Juliet Harris, Together Scottish Alliance for Children's Rights, said that the very process of incorporation brings about a culture change in which children and young people are better recognised as rights holders. Former member of the Scottish Youth Parliament for LGBT Youth Scotland said, "It's easier to look at a written document that says that these are the things I should have, rather than kind of guessing what you think you should have. This is empowering for me as a young person." The bill will require that ministers publish a children's rights scheme setting out the arrangements the government has in place or intends to put in place to fulfil the duty to act compatibly with incorporated UNCRC rights and obligations. The government and public authorities will also be required to report on steps they've taken to be compatible with the incorporated rights and obligations. So in conclusion, Presiding Officer, I think this bill is a game changer for children and young people, and it's a milestone for Scotland, and I will be very proud to support the general principles at decision time today. Thank you.
Thank you very much, Ms Mackay. I call Alison Harris, the last speaker in the open debate. Ms Harris, please.
Thank you, Deputy Presiding Officer. As a member of the Equalities and Human Rights Committee, I'm pleased to speak today on the issue of children's rights, and I hope we are able to do it justice with the progression of this bill in the few weeks we have left of this Parliament. It appears there is broad agreement across all parties that the issue of children's rights should be absolutely paramount, and that sentiment is also supported by Scotland's major public sector bodies too. I believe it's imperative that Scotland catches up with the other countries who have successfully implemented this legislation. That's because the evidence is clear. A study commissioned by UNICEF found that in every country where this has been brought in, it's had a significantly positive impact. As the report itself states, successful CRC implementation is key to the realisation of children's rights. Where this has happened, it has had significant effect. We want it to have that impact here too, and that's what our young people need. From speaking to young people who would benefit most from this legislation, some things are abundantly clear. Firstly, this cannot simply be another paper commitment. The content of this bill must become a reality for young people in Scotland and not just the usual warm words. Young people need the government to put someone by their side to protect their rights. And many of the points in this legislation should make that happen. It's vital that vulnerable young people know that we are on their side. Whilst it's impossible to disagree with the aims of strengthening children's rights, the Equalities and Human Rights Committee did hear a number of submissions which raised potential technical problems and unintended consequences. And while we accept and support the basic principles set out, there's no getting away from the fact that there could be potential problems going forward. For example, there was concern that only public bodies would be covered by this legislation. That doesn't take into account private companies who operate contracts on behalf of the public sector, such as a firm who may look after severely disabled children as part of a local authority arrangement. We also heard from those who were worried about some vulnerable young people. They may reach the age of 18 and effectively become age barred from a support point of view. There should be potential through this legislation to make sure that people aren't allowed to disappear off the radar, as the transition into adulthood for these young people and their families can be the most challenging times of their life. Some witnesses spoke of these time limits and their fears that a person may want to take retrospective action later in life when they realise their rights were infringed as a child, or they are finally able to confront those facts. We must also think about the finances of this. There's no point passing legislation like this if the resources aren't there to support it, so it's imperative that we're upfront and honest about costs. It would be damaging for the bill if the initial cost was set out only for that to significantly increase over time in add-ons. The public expect the state to invest in bills such as this, but they also expect their money to be used wisely and for the benefit of these financial commitments to be shown. Yet already concern has been raised by the Faculty of Advocates that the £2 million mentioned wasn't realistic. They pointed out to MSPs the financial consequences are potentially very significant and likely to be underestimated in the financial memorandum. Additionally, some concern was expressed in the final report that the Scottish Government hasn't yet put a timeframe on when this legislation will come into effect. Timing is a very important point here, and it cuts both ways. Of course, when this is finally passed by Parliament, the Scottish Government has a duty to get moving and implement the principles voted for. But it can't be rushed. And I'm very concerned that we're only a couple of months from the end of this parliamentary term, yet this enormous piece of legislation still has to clear notable stages. If we hurry this through and make bad law, the consequences for young people could be severe and possibly leave us all in a worse situation than we're in currently. As well as the shortness of time, we also have to bear in mind the dominance of the COVID-19 pandemic in terms of parliamentary business. Not only is it limiting the days we meet, but when we are here, it's dominating the agenda, and that, of course, is understandable. But it does add pressure to an already tight timeframe. Deputy Presiding Officer, rarely have children's rights ever been put under more pressure than through the coronavirus crisis. Whether that's through schools closing, exams being cancelled, or a loss of social opportunities that generations before them got to enjoy. The odds really are stacked against vulnerable children in Scotland. This isn't a case of making sure children know their rights. It's a case of adults and public organisations taking responsibility for those rights. The Scottish Conservatives will vote for the general principles of this bill and scrutinise any aspect of it which needs further strengthening as the bill progresses through stage 2 and to stage 3. Thank you.
Thank you very much. I move to closing speeches. Mr Gray, you'll need to put your card in for anything to happen worthwhile. After all this time, it's so easily done. Colleen Gray to close for Labour.
Thank you very much, Presiding Officer. I'm delighted to find myself closing this debate for the Labour Party today, as incorporation of the UNCRC into Scots law is a policy we've long supported and believed to be now overdue. Indeed, looking back, I saw that Kezia Dugdale was pressing for it 10 years ago when I was her leader, and it featured too in our manifesto in the run-up to the last elections. So I'm delighted that it is now before us, that the government have brought it before us, and that it does have support across the chamber. Outside Parliament too, support for incorporation has grown over those years, especially in Scotland's youth and third sectors. The very organisations who understand the real impact that incorporation into Scots law will have on the lives of our young people. Several speakers indeed have referred to Together, the Scottish Alliance for Children's Rights, and it is really, I think, an unprecedented alliance of 50 member organisations who have welcomed the introduction of the United Nations Convention on the Rights of the Child Scotland Bill as a step forward for Scotland to help ensure a comprehensive approach to children's rights. And I think Alex Cole-Hamilton was right that the bill has in fact lived up to the expectations of the sector. The incorporation of UNCRC, of course, will finally provide a proper framework for the provision of children's rights in every part of Scotland and at every level of government. And it will lead to greater consistency of children's rights, in particular, as many speakers have referred to, the right to be heard and to take part in decision-making that affects them. And it is, I think, to the credit, and a number of the members of the committee have spoken this afternoon, that listening to children and giving them a part in this decision-making has been an important part of the process. Now, Wales, like Scotland, have also previously passed legislation requiring ministers to have regard to the UNCRC, and indeed in England, the Children's Commissioner is also required to have regard to and monitor the implementation of the Convention. However, the Deputy First Minister was quite right when he said that this will make Scotland the first country in the United Kingdom to make the Convention and these rights fully legally enforceable. And that is very much something that we can be proud of. Of course, we're not the first country in the world to take this step, and Alison Harris was right a moment ago when she said that international evidence shows that in those countries where incorporation has taken place and UNCRC has formal status, it clearly improves the outcomes for children. Indeed, it does this by becoming an influential touchstone for decision makers, effective across legislation, policy and practice. And that results in a culture change which directly impacts on the application of children's rights and principles in national law and policy. Ross Greer made a very important point that the UNCRC and the legislation before us could be seen as a kind of dry legislative process, but the fact of the matter is that it does and will affect the real daily lives of children across Scotland in the future. Now, passing of this legislation may be a necessary condition for that culture change that we want to see. But as a number of speakers have said, it is not sufficient. We and our successors will have to show ourselves up to the challenge of making these rights real. And our track record isn't always the best. Mr Cole-Hamilton was right to point out that it is years now since we passed a law to raise the age of criminal responsibility to 12, and patted ourselves in the back for doing that at the time. And yet that has not even yet been commenced. And the fact of the matter is that 12 would not, by the standards of UNCRC, be enough. It should be 14. The fact of the matter is that as of today, our age of criminal responsibility remains at 8. So no wonder, I think, then, that the committee do see it as being... Surely.
Alec Cole-Hamilton.
I'm very grateful to Ian Gray for giving way. And does he recognise that while we have an age of criminal responsibility that is 8, we are still lower than anywhere else in the British Isles, but also lower than those human rights exemplars of Russia and China that we would otherwise seek to sit in judgment of?
Ian Gray.
Well, that is the case, and I think it just makes it worse to know that we have passed a legislation to move on from that position, but it hasn't commenced. And that's why I think that many members of the committee speaking this afternoon have made clear that they continue to believe we should amend the legislation during stage 2 in order to put a commencement date on the face of the bill, and I hope that the Deputy First Minister will look at that. A number of speakers have talked about UNCRC in the context of the COVID crisis. And I think that is right, because there also, we've not always been as cognisant of children's rights as perhaps we should have. The Children's Commissioner has been consistently critical of government, believing that ministers have not done enough to protect children's rights to an education in the light of school closures. And the SQA Our Say project has given voice to young people who believe the certification appeals process breached their rights. My point, I think, is that children's rights are a real thing affecting the real lives of children day by day. And in fairness, I think Mr Swinney and the SQA have acknowledged this, and we hope that that will lead to a different approach in the months ahead as we continue to try and deal with the impact of the pandemic. So children's rights are more than an intellectual or cultural construct. They impact powerfully on children's lives. And the legislation that we pass today, therefore, is of critical importance to future generations. I believe it will pass in principle later this afternoon, and that will be a good afternoon's work on this Parliament's behalf.
Thank you very much, Mr Gray. And I call on Rachel Hamilton to close for the Conservatives. Ms Hamilton, please.
Thank you, Deputy Presiding Officer. I'm delighted to close tonight for the Scottish Conservatives, and I want to firstly put on record my thanks to the Equalities and Human Rights Committee for all their work on the bill. It's taken some time, but we're finally here, albeit with a worryingly short time to see its passage through the Parliament. The UNCRC was a milestone treaty recognising the importance of childhood and the unique needs of children across the globe, when for so many years children's rights had been ignored. And it's heartening to hear the passion for this bill exuded by many members in the chamber today, particularly the contributions from Alex Cole-Hamilton and Mary Fee. Alison Harris rightly said that vulnerable people should know we are on their side, and the Scottish Conservatives want to see children and young people included in all aspects of life and tonight we will support the general principles of the bill at stage 1. However, at later stages, we will seek to submit amendments to ensure that the bill is strengthened to reflect the concerns of a range of stakeholders, public authorities, Children's Parliament, the Scottish Youth Parliament, the Law Society, and organisations involved with children's rights. As with all legislation, we must first analyse what the current legislation is failing to achieve. This is not a silver bullet. It is the case that there are a whole host of current pieces of legislation covering numerous aspects of the UNCRCR already, from the Children's Scotland Act 1995 to the Children's Hearing Scotland Act 2011. It remains the case we could go further right now in protecting and upholding those rights with the current range of legislation. Furthermore, this bill must see any future legislation assessed for its compatibility with UNCRC requirements. In Scotland today, children have been let down on a range of issues. John Swinney is right to want a fair and equal society for children. We all do. He talks about the effects of the pandemic, but we know there were deficiencies that left children behind in Scotland before the pandemic. Without rerunning the wide-ranging, strong arguments heard during committee evidence, one would hope the bill will improve the outcomes for all children in Scotland, especially for education. And I want to echo what Ian Gray said in closing for Labour. Whether it's falling standards in our schools, the SQA exam results fiasco, or the disproportionate effect of the COVID-19 pandemic on children and young people right across the country, children have a right to a good education, a right to development. Since day one of the pandemic and the subsequent lockdown, a child's right to education has been hindered. Professor Lindsay Patterson, Professor of Education Policy at the University of Edinburgh, collated research estimated the educational gap caused by school shutdown. Education Secretary announced an additional £100 million to be invested over the next few years to tackle the impact of lockdown on schools and pupils. Yet, we still hear from those in deprived areas being unable to keep up with online teaching due to a lack of technology. Children across the country are having their teaching hours cut due to remote learning, while some in rural areas, such as many of my constituents, are struggling to gain access to a full range of online tools due to poor broadband, as mentioned by Elaine Smith. Indeed, some newly formed groups may ask if children's rights have been respected in balancing health risks over educational development. Do children have the right to social interaction, as raised by Jamie Green? In the submissions to the consultation on UNCRC, Dr Kirk of Glasgow Caledonian University highlighted the damage caused by the SQA exams fiasco back in August, where she believed the right that children have to be listened to was ignored. In terms of that process, all groups who took part in the community engagement work mentioned the lack of redress as an example of a time where their voices are ignored. One young person stated that the 2020 SQA process had been a kick in the teeth and went on to say how this impacted upon their mental health. As Mary Fee said, this bill will give children more power. I would like to just raise quite quickly a concern that I have over the impact of the bill has on cross-border children who are educated on one side of the border. Perhaps they come from England and attend school in Berwickshire. I believe that it raises questions about how this bill might work with the UK Human Rights Act, especially when children from England attend Scottish schools, and this needs to be clarified, which I intend to pursue. And my colleague Alexander Stewart has already reiterated the point that Section 11.3 requires strengthening, and Fulton McGregor raised the need for the Scottish Government to strengthen Section 11.3 by amending the wording from may to must in order that they must set out a children's rights scheme in the bill. And I believe the Scottish Government are committed to that. Many of my colleagues speaking today have raised the concerns of stakeholders such as the Law Society, noting the number of duties being placed on public authorities and that this is likely to continue to grow. We do not yet know how much it will cost to train staff in public authorities and private contractors that are used by public authorities on UNCRC, and this could lead to significant financial implications. In conclusion, Presiding Officer, it is the case, Presiding Officer, that at stage 2, amendments will have to be made to this bill in its current state, and we will work in the short time frame that we have with our parliamentary colleagues to make good law and not bad law to incorporate UNCRC into Scots law as far as possible within the Parliament's powers. Tonight, Presiding Officer, we will be supporting the general principles of the bill. Thank you.
Thank you very much, Ms Hamilton. I call John Swinney to close the Scottish Government. Deputy First Minister, please.
Thank you, President Officer. Let me draw this debate to a close with a word of thanks to members of Parliament across the political spectrum for their contribution to the debate and the support that's been expressed for the legislation that is before Parliament at stage one. And it is, I think, properly reflective of a landmark day when Parliament considers legislation of this magnitude. And that, of course, has been helped by the scrutiny that the committee has given to this piece of legislation, and I'm grateful to the convener for the remarks that she made about the bill and the issues that arise. I'll say a little bit more about the commencement issues in a moment, but Ruth Maguire specifically raised with me the issue of ensuring that children with protected characteristics are recognised in the bill. I fully support that objective. But the mechanism by which the government has opted to take this issue forward is by essentially incorporating Article 2 of the Convention, which assumes that there can be that children's rights are guaranteed without discrimination. So that provides essentially a universal protection for children and avoids the necessity of specific listings of protected characteristics. Now, obviously, we will reflect further on the points the convener has made, and I'm happy to engage further on this question. But that's the approach that we plan to take. I'll give way to Neil Finlay.
Thanks. I haven't been following this bill very closely, but I'm very interested in this point. I got a parliamentary answer back today saying that the government didn't know how many children were not accessing online learning, similar to the point Elaine Smith was making. Given that the government is deciding on budgets to provide additional resources to local government, yet they don't know the extent of the problem, how would this bill coming forward ensure that things like that were not repeated and that children all had access to online learning?
Deputy First Minister.
Well, Mr Finlay clearly hasn't been following the debate, because we did a data collection exercise with local government last summer, which identified 70,000 young people who did not have digital connectivity. We therefore put money in place which enabled 70,000 young people to get digital connectivity. Now, we continue to engage with local authorities on this question, so that deals directly and firmly with Mr Finlay's particular point. Now, if we then look at the question of commencement, I acknowledge the significance of the point that's made by the committee in relation to commencement timetables. And I want to address some of the issues that have been put on the record by Alec Cole-Hamilton, because as often is the case with Mr Cole-Hamilton, it's not always as it is set out in what he says to Parliament. In relation to the commencement of the Age of Criminal Responsibility Scotland Act 2019, the first set of commencement regulations came into effect on the 29th of November 2019. They removed the offence ground for referring a child under 12 to a children's hearing and commenced provisions for victims. Since then, it's only been possible to refer a child under 12 to a children's hearing on welfare and protection grounds. This means it has not been possible for children under 12 to obtain criminal convictions since the end of 2019. So for all intents and purposes, the age of criminal responsibility is effectively 12. There is a complex set of regulations have to be put in place. The second set of regulations were put in place on the 30th of March 2020, the third set on the 30th of November 2020, and Part 1 of the Act will be commenced as part of the final set of commencement regulations planned for autumn 2021. So I simply put that detail on the record to make it clear that what Mr Cole-Hamilton was putting on the record earlier in Parliament is not a clear, accurate and comprehensive distillation of what's actually happened here.
Before you take the intervention, Cabinet Secretary, don't keep on your feet. I don't have two members on their feet at the same time. Mr Hamilton.
My apologies, Presiding Officer. I'm very grateful to the Cabinet Secretary for giving way. I'm also very grateful for him illuminating the Chamber as to the commencement, and that some of that was news to me, so I'm very grateful to him for that. However, is it consistent with the warm words that we have heard in this Chamber today about children's rights that our age of criminal responsibility, when it finally reaches 12, will still be 2 years south of the UN Committee on the Rights of the Child's recommended international minimum?
Deputy First Minister.
Well, I'm grateful for Mr Cole-Hamilton confirming to Parliament that his comments earlier on were not well informed and that he didn't actually catch up on the detail. And I suspect that reinforces the point that I made earlier on, that we should consider very carefully the points that Mr Cole-Hamilton puts on the record before we accept them to be accurate. Now, the issue on the age of criminal responsibility is an issue for which Parliament has legislated, and obviously the contents of the bill that is before Parliament today provides us with the opportunity to consider these issues as the age of criminal the commitments given by the Government on the age of criminal responsibility do likewise. Now, I want to agree very much with the sentiment that Ian Gray and Ross Greer and Mary Fee put on the record about the importance of the legislation having an impact on the lives of children and young people. It is absolutely critical that the legislation is brought to life in ensuring that children have a different experience within our society. There are challenges about the way in which we respond to the application of the rights of individuals in our society, particularly during COVID. There are multiple factors that government has to weigh up. Yes, of course, children are entitled to an education, and they are receiving that education through the delivery of remote learning, because we would not be doing children or anyone in our society any favours if we did not take the measures necessary to suppress the prevalence of coronavirus. So there will be competing factors that affect the way in which we can exercise the rights of individuals. I want to pay tribute to Mary Fee, who has given a huge amount to this debate over many years and has championed many of the issues, and I was particularly heartened by the comments that she made and also Elaine Smith made about the bill that is before Parliament today. And one of the points that Elaine Smith made that I want to agree with very much and commit to is the importance of changing mindsets as a consequence of the passage of this legislation, because fundamentally that is what we have to do as a consequence of the changes that are proposed to be made here. Gillian Martin highlighted the importance of communicating the rights that will be assured by this legislation, and the Government commits itself to supporting such an endeavour, and I know there are many stakeholders who will be willing participants in that whole process. One of the other issues that was raised by Alexander Stewart and also by Jamie Green was the relationship between the rights that are being assured here in this legislation and the interaction with other human rights legislation. Now, as members know, and it's been acknowledged in the debate, I have taken a maximalist approach. I have sought to ensure that within the constraints of the legislative framework within which we operate, we do as much as we possibly can do to assure the incorporation of the maximum range of rights of the United Nations Convention on the Rights of the Child into domestic legislation in Scots law, where we have the legislative competence to do so. There are, of course, areas where I would like to assure rights further, but I fear, and I put this on the record in Parliament today, I fear that some of that context may well be eroded by the approaches that have been taken by the United Kingdom Government on questions such as the Human Rights Act and the European Convention on Human Rights. I worry that the maximalist position that we are taking here in this legislation may find itself, perhaps, rubbing up against an approach to rights within the United Kingdom that may erode some of the things that we all in this Parliament might well believe to be important and valuable and should be assured, but they may be taken out with our competence to be able to resolve because of changes to rights legislation elsewhere. And it's an issue that Parliament has to be very mindful of as we consider the questions that are before us in relation to this legislation. In conclusion, Presiding Officer, Rona Mackay indicated that she described this legislation as a game changer for Scotland and a game changer for children and a milestone for Scotland. And I think those words are a very appropriate sentiment on which to close my contribution, to commit the Government to engaging constructively with the committee at stage 2 on the issues that I have raised and on the other issues that have been raised within the debate today, to find ways of addressing the aspirations that all members have to ensure that we successfully incorporate the United Nations Convention on the Rights of the Child into domestic Scots law. And we do that at a moment when we can assure children of their rights within our country and do everything within our legal framework to ensure that is the case. And we must then build on that by ensuring the awareness and the understanding of those rights is there for every child, and they can experience them and live with those rights here in Scotland. Thank you.
Thank you very much, Deputy First Minister. That concludes the debate on the United Nations Convention on the Rights of the Child Incorporation Scotland Bill, and we will shortly move on to the next item of business.